May it please the court. I'm Ingrid Anderson. I represent the appellant. I would like to reserve 5 minutes for rebuttal. Can you hear me okay?
Could you maybe move, if you could move just a little bit? Thank you, ma'am. Appreciate it.
How's that?
Perfect.
There are two primary issues in this appeal. The first involves some missing diamond rings with a value of over $500,000. The court distributed these rings when the rings had been determined missing by the predecessor judge. This case began in 2012, but in 2015 there was an evidentiary hearing on the jewelry, and the trial court established that these rings were missing. That ruling has never been overturned. In fact, throughout the final hearing, both parties referred to these rings as missing. There was no real dispute that they were in existence. There was some dispute about how they became missing, but there was insufficient evidence to show how they became missing.
Here's the thing about this, though. But if I remember correctly, both sides were basically pointing the finger at each other as to who had the rings, even up to the point of trial, correct?
Yes, but it was more one-sided. It was, yes.
At page 1313 of the record, after going over with Judge Stoddard about how Judge Bauman had previously determined that he couldn't tell who had the rings, Ms. Everett's counsel, Ms. Coleman, says, all that matters is where the $400,000 ring is, Judge. That goes on somebody's column, and that's where we want to go. She's asking for the judge to decide, look, this has got to be put on somebody's column, and the only way you get there is the only way you can make that argument is just to say that they're not missing, one of them's got it, you, judge, decide who's got it. How else do you read that?
Well, Ms. Coleman was initially arguing that the husband had taken the rings.
Right.
And she was hoping to win on that.
Sure.
But at no point was it considered to any extent that she had the rings. The wife was living in the home. She alleged that the husband came. This is during the separation.
Right.
And he had taken them. Husband's counsel did accuse wife of taking them, but the trial court found that there was insufficient evidence of that. And that was the same ruling that the Judge Bauman had made earlier. In the examination of the factors for equitable distribution, intentional dissipation, waste, the last one, the court found that there was insufficient evidence to support the accusations of either party. So that was a finding that...
Well, so you can construe that one way, the way you're saying, which is that the judge basically said, I have no idea where the rings are. Or you could construe it to say, hey, I don't think anybody necessarily stole these rings from anybody, but I'm concluding that the wife's got them. Right?
No, I don't think so.
Why not?
I don't think... You have Judge Bauman saying that both parties deny having them.
Right.
For that ruling to be modified, there needs to be something fairly definitive to say that there's a different ruling, that there's a different circumstance. I don't see the judge...
That's not exactly your argument, though. Your argument in this appeal is that these rings just shouldn't have been included as marital property.
That's true.
Which, if we were to write an opinion, that would probably come as a surprise to the judge that presided over the trial, because the attorney for Mrs. Everett said, Judge, that goes on a column somewhere, you have to distribute it.
But she also said that the rings were missing. She said that in a couple of other times in the proceedings.
It's pretty clear that what Ms. Coleman wanted, that the tack that was chosen was, we are going to advocate that these rings were stolen and that they're going to be ascribed to Mr. Everett. That was the tack that got chosen, but the trial court made a different finding, right?
The trial court never made a finding other than the whereabouts are unknown. These rings were not in existence at the date of filing, according to Judge Bauman. Nobody knows where they are. They should not be included in a distribution absent a specific finding of misconduct, and the court did not do that. The court specifically said there was insufficient evidence of any misconduct by either party other than the $900,000 in
But nobody suggested to the trial, nobody ever argued to the trial court, this is non-marital property, correct? At any time in the trial, was that argument ever put before the trial court? This is non-marital property, don't include it in ED.
I think that Attorney Coleman, we think he took them.
Yeah.
But if that can't be proven, then the law applies. The law 6107 has to govern. The jury had to be in existence at the date of filing. And here it wasn't, and there was no finding that it was not there because of misconduct. That's just equitable distribution law. To try to hold, to disregard Florida law because a party is making an argument that in the end was not supported by sufficient evidence does not change the duty of the court to comply with 61075. And the reason in the final judgment, the judge specifically says why he allocated that to the wife. And it wasn't because he thought that the wife had the property. He said he did it because in the proposed final judgment, which was a clerical error, the Coleman had included those rings with the other jewelry that was divided by agreement. That is why he did it. He did not do it because of some argument or finding that it had to go in somebody's column. He did it because there was a scrivener's error in Ms. Coleman's proposed judgment. And he says that right in the final judgment. This was just a scrivener's clerical error, and that's all there is to it. Repeated during the proceedings.
Let me follow up with that, because I know you're taking the position that it was a scrivener's error, and I believe there was a motion for rehearing, a motion for clarification, motion for the court to make a determination that was an error. But the court chose to deny that, and by choosing to deny that leads to the conclusion that the court did not believe it was a scrivener's error, that this was something that maybe the wife had asked for, that all the jewelry would be awarded, at least for all the woman's jewelry would be awarded to her. Why is that not an appropriate determination in reviewing this record?
I can't explain why the judge did what he did. I can say that this was a 5-year proceeding. This appeal is already approaching 2 years. That there was a lot of accusations going back and forth, a lot of accusations that in the end were not provable. That's all I can say. I can't say why he did that, but I can say this. In the motion for rehearing, Ms. Coleman doesn't exactly say that it was scrivener's error. She says the court misunderstood the agreement of the parties, and the agreement of the parties was described in the final judgment, which contained the scrivener's error. I'm guessing she didn't want to admit she had made a mistake. But she said that the court's understanding of the agreement, which is what the scrivener's error was all about, was inaccurate, and explained that they were missing. And there she does say that they are missing. So whatever her position was, she clarified it. Of course she wants it to be credited to the husband, but if not, I don't think she ever conceived that it would be credited to the wife.
Let me ask you this. Just suppose we were to go with your argument that, hey, there was just a violation of the law here, this judgment, you know, to the extent it was an evidentiary ruling as to who had the rings, it was an abuse of discretion, what have you, and we were to reverse. What would you suggest we do on remand?
On remand, you take the rings out of both columns. Then wife has a deficit of about half the value, which, over $250,000.
Yeah.
Then you award her $250,000 of the assets, which is the husband's pension.
There is no
It's the
way we
husband's
could
pension.
do that on remand without allowing the court to reopen equitable distribution and alimony. You can't just have the appellate court move over $250,000 from one column to another in a disputed issue like this without saying, hey, this may have an effect on what the trial court ultimately concluded based upon its findings, what a fair and equitable distribution would be, and what alimony would be.
Well,
potentially you are asking to open up these proceedings again.
I think you could, because this is a fairly discrete issue. It was a clerical error. If she had not written that in the proposed judgment, we wouldn't be here, and the court made that very clear in his written judgment.
Let me follow up with that, because this is a pretty significant amount, and we can't just simply say, let's shift certain monies to make everything. I mean, it has to go, if we remain this, it has to go back for a full-blown hearing for the court to determine, again, equitable distribution. And I want to make sure that, I hope you agree with that. You're suggesting that that's not the case, and it's simply for us, at our level, just simply say, okay, let's just shift X amount?
Well, I see this as a fairly clear, discrete issue. I just don't see anything in the record to really indicate that there was any support that the wife had these rings. So it is an equitable distribution. If you need to reopen it, then you can order that. I just see this as a very discrete issue. These rings, to have the wife get $250,000 less in equitable distribution for rings that she doesn't have, that the husband in his proposed judgment said they were unlocatable, that the Judge Bauman did, that Judge Stoddard never really changed that, is just not fair. This is an equitable distribution. And repeatedly in this case, I think Judge Stoddard felt bad because they earned a lot of money. The husband was a professional ball player. He earned a lot of money. And there was very little left at the time. So I think that he kind of struggled, and perhaps that's a reason why he might want to reconsider the entire distribution, because this does change the complexion of it. But the issue itself, I think, was simply a mistake. But for that proposed judgment, we wouldn't be here. And that, Coleman does clarify in the motion for rehearing that that was a misunderstanding of the actual agreement. And when, I think you probably are aware that often trial judges, after a long trial, and they feel like they've gotten it, they don't want to go over it again. Denials of rehearings happen. But she filed then. She wanted to get the transcript to show that, the rings were gone, that she had all the excerpts regarding jewelry transcribed, and she wanted she wanted to set aside that till she could get the transcripts to show Judge Stoddard, and he denied that, which, it is a lot of money. You would think possibly if she wants the transcripts, that give her a chance. But it didn't happen. This was this was just a tragedy. This was a mistake. This wasn't a substantive decision. And it's very clear in the judgment. The judge writes he doesn't find that the ring should go into the wife's column because of she has them or she should have them or anything. She said it was because of the proposed judgment. I think...
Ms. Anderson, excuse me, you're up to about 15 minutes, so use your time as you wish, but I just want to give you the heads up.
Okay, let me just touch on the second issue very briefly, was the failure to award nominal alimony. The court found it was a long-term marriage. The court found that the wife had need. Neither party was working, so husband had no ability to pay. His reason for denying alimony, he did not address the presumption of alimony in a long-term marriage. His reason about the unique circumstances where the parties equally shared in the dissipation of the marital wealth just is not legally sufficient. It doesn't come under the just and equitable circumstance, the catch-all phrase in 61.08. It is beneficial to the husband and prejudicial to the wife. So that is not fair and equitable. So I believe that's an error of law. There was legally insufficient basis to deny alimony in a long-term marriage with a presumption of permanent alimony. Thank you.
Thank you. Ms. Thompson?
Good morning. I don't mean any disrespect by the code. I have some health issues. One of the issues we're here to address today, I want to start off with where she left off with the alimony issue. This was a case where the parties earned a lot of money. And I said the parties because at the time Mr. Everett earned the money, he was married. So it was their money. It was not his money. He may have contributed to labor, but it was their money. And turns out the whole time they both spent the money. Neither one of them spent the money wisely. They both had a high school education. The wife takes the position that because at some point they lived an extravagant lifestyle, she should be entitled to continue to live in that manner. But part of what Judge Stoddard recognized was that living in that manner is what caused the depletion of the marital estate. At one point, as I've said in the brief, they had 3 houses. They lived in one. They had all the bills for 2 other houses. They didn't even bother to rent them out. That was tragic. They were young and in some respects foolish in terms of how they managed their money. I suspect they perceived that it would always be there. Today, both of them have imputed to them a minimum wage. Mr. Everett has no more marketable skills than she does. How is it that he would be in a position to suddenly resume earning enough money so that she could live at a value of approximately $17,000 per month? It's perplexing.
Well, I think, you've couched it in your brief as sort of an all or nothing proposition, that the only reason, that basically there's no chance that he's ever going to make the kind of money he did when he was playing in the MLB, and therefore the presumption of permanent alimony is rebutted. And I don't understand their argument to be quite that extreme. I think it's more along the line of, hey, there's some other venues, some other opportunities he could pursue. I don't know that they ever put any, established any of that in the record as evidence, but they advanced the argument that, you watch the MLB Network, you watch ESPN, there's commentators, there's reporters, there's, back office people, coaching, private coaching, one could imagine other roles that he could find himself in that pertain to baseball, which is the skill that you all concede he had. He was a good ball player, and that he could make some money in the future. How do you address the denial of nominal alimony given that? Or is it just simply a question of, hey, look, they didn't put anything on the record that shows you how it would happen.
No, it's two-pronged. For 10 years, he no longer played baseball. For 10 years, he didn't earn any money. So all of a sudden, somehow, over the next 10 years, he's further away from his career as a baseball player. There's more baseball players who have retired, who are closer to the game, and the community might recognize those names. Turns out more often than not, when you're a big league sports athlete, your name has greater value as soon as you leave the sport. His name didn't have superior value because he had a lot of baggage that he
Right.
dragged along.
No, and I understand that. I think what Judge Lucas's his question, which is similar to my question, we realize that's what was mentioned, but what was also presented before the court, you never know what may happen 10 years down the road. You never know. Maybe ESPN decides, oh, let's get someone of his caliber come in and to comment. You never know what will be the future. And so for that, wouldn't it be appropriate just simply to award nominal alimony to keep that in the event something like that happened down the road, given someone of his caliber, a great baseball player, accomplished a lot? Why isn't that something that could be considered to be a mistake on the trial court's part in failure to do that?
Well, the case law, as I recognize it, says that you should not determine alimony based on some future event that might possibly happen at some future time. And that's what we have here. This is not a scenario where his income suddenly changed and it was a short-term decrease. This is a guy for 10 years, neither he nor the wife had any income. Now, what the record also discloses that at one point, Mr. Everett did make a motion to be able to relocate to Texas so that he could pursue job opportunities. The wife opposed it. After opposing these opportunities, at the trial, she says, oh, he could have had these jobs. What else did she do to impair his ability to earn money? Every time he got arrested, it was all over the news. She had him arrested in Tampa. He was arrested in Texas. Those are two of the markets where he had played professional. Well, one is his home and one is where he had played. He was trying to return to Texas. She said no, he had him arrested there. At what point does your ability to market yourself get impaired by the other things? Who would want to bring you onto their program when you have an allegation out there that you pointed a gun at the head of your wife with your children present? Nobody wants to bring that into their franchise. There's too many other players and other options that you don't have to bring nonsense into your bullpen, for lack of a better description. So the notion that after 10 years he was unable to find a job in this business, that at some point 10 years from now he should, at what point does this marriage actually end? It's already had 10 years of no income, 5 years of the litigation, still no income. At what point does it become necessary for her to support herself and him to support himself?
So you're basically suggesting, and part of your argument, that it's because of her actions, and this is what the court recognized, her actions that she has done somehow impeded his ability.
It's marketability.
And that was a definite, at least as I'm hearing your argument, this is what you said, that the court concluded.
No, I said that was part of the argument, and that's borne out by the evidence. Her son said that he never pointed a gun at her, but she had him arrested and accused him of pointing a gun at her in the presence of the child. That made the national headlines. That was at a time when he said that he was supposedly trying to figure out a way to go earn money. That was at a time where he was closer to the business side of the business, Major League.
We don't have to decide whether the allegation is true or not. Your point is the fact that there was an allegation undermined his marketability.
Absolutely.
Okay.
Sort of like, R. Kelly right now, I wouldn't invite him anywhere. Some people might think he has a great song, What I Believe I Can Fly. I wouldn't play it. But beyond that, not only did he talk about the marketability issue, the wife leaves this marriage with more than the husband leaves. Why? Because according to the trial judge's finding, he spent too much money at the casinos, okay? So here we have someone with equal skills, equal education, both of them have imputed minimum wage, who should now say that although I'm leaving this marriage with more than he is, I think he should still be on the hook for the rest of his life, essentially, so that if he ever earns something, I can go back and ask for a part of it. At what point does the marital relation end? This marriage has been over for now, it seems, 7 years. They left the home in April of 2011, it's now 8 years. I believe Mr. Everett should be allowed to go his way and live his life, even if it's a lot poorer. One of the things that was mentioned is that the court's order uses a specific language, and it's the only basis for denial of alimony. But if you look in the final judgment, starting in paragraph 9, I want to be clear. The court says, the court denies the wife's request for the reasons stated herein. And then he goes and he analyzes section 61.08. The wife's argument focuses on subsection J, one sentence, and ignores all of the other factors that are in the other provisions of paragraph 9. And so I believe that's a disservice to the hard work that Judge Stoddard did. Judge Stoddard is an experienced trial judge, to say the least. My understanding, he's been on the bench since 1997, and he's done quite a number of family law cases. The way he shepherded this case through, he was patient. He took hearings on dates that worked with the parties. To suggest that he was unaware that there was a rebuttal presumption, I think, is a disservice to him. There are no magic words. There's case law that says you don't have to use magic words. The Hugh Sung case, which is cited by the appellant, specifically states that the process that the judge used is a process that is appropriate, because the court in that decision, although it's out of the fourth, it says, however, this is by no means an irrebuttable presumption. A trial court can overcome it by making detailed findings of fact regarding a spouse's need and the other spouse's ability to pay, as well as by considering all the relevant statutory factors listed in 61.08, subsection 2. And that's in the Hugh Sung case at page 588. So in fact, Judge Stoddard did precisely what this case said. He found that the husband did not have the ability to pay, and then he went on and he considered those other factors. I want to turn now to the issue of the carbon copies. I recognize that this seemed to be a bouncing ball. At one point, the argument was she should be able to testify with them. There was no lawful basis for allowing a witness to sit and testify with these carbon copies. And then the argument changed that she should be able to use them to refresh her recollection. What the court surmised was that she wasn't trying to simply refresh her recollection. She was actually going to use them as her testimony, because she had these carbon copies for years. Now, the carbon copies became a big point of dispute because they showed up for the first time in the middle of the trial. The wife was requested to provide evidence as exhibits that she would rely on at the trial based on the court's pretrial scheduling order. Never turned over. In 2013, the parties made a stipulation. It's in May of 2013 that they're going to turn over all of the things to the accountant. The accountant was using carbon copies. The wife gave carbon copies of her mother's account, but she didn't give this set of carbon copies. And the response was, they didn't ask for them. Well, the agreement was you were going to turn over everything. And I make that point to say that throughout this trial, what it appears was the wife made a deal, she got what she wanted out of the deal, and once she got what she wanted out of the deal, she reneged on the deal. And that was a pattern that was exhibited throughout the case. The wife had a house for her mother. She said she bought one for my client's mother. My client's mother died. She wanted the house to revert back to the marital estate, but she wanted her mother and her to keep the other one that was out of the marital estate. So what you saw happening, and I'm certain Judge Stoddard saw it, was I'd call it a shell game. I'm going to give it to you on one hand, I'm going to take it back on the other. The carbon copies were part and parcel of. I didn't have to turn it over. All of a sudden it's relevant. There are hundreds. Apparently they're from 2000 to 2006.
You say the word apparently. Were the carbon copy checks ever proffered in the record below? In other words, here's what we want. Mark them, put them in.
I would not be able to answer because when I was looking at that, it looked like she tried to proffer them. I don't see them in the record, but that was the appellant's.
Right. I'm not putting that on you. I'm just asking if where I could go in the record to look at these carbon copy checks, if I wanted to look at them to determine whether or not there's anything there.
Not only have you not seen them, Mr. Everett and his counsel has never seen them to this day. Because again, when they did try to make arrangements, Ms. Everett's counsel, she said, no, you can only look at them at my office. She refused to allow him. This account supposedly belonged to the two of them. How come she had a superior right to these carbon copies? Nobody has explained that yet. She said she'd turn them over to a copy service, but she wouldn't allow the husband's attorney to review them. She doesn't say why. It's just, I've made a decision that you're not allowed to see these on your own. In other words, I get to supervise you as you get to go through these carbon copies. That's not a way that you cooperate when you're talking about a discovery issue, when you're talking about money, when you're talking about this kind of, this number of documents. It's just not something that's typically done. And last on that point, as I said before, one of the things that they talk, when she talks about, and I'm talking about in the trial court, when the trial attorney is talking about these carbons, at no point did she proffer these, did she lay the proper predicate for the admission of these carbon copies. So when Judge Stoddard said, you should have turned them over to the accountant, I'm not going to let you sit here and bog down the trial, because she wasn't going to refresh her recollection with 6 years of carbon copies. What she was going to do is she was going to use them as actual testimony, and that's inappropriate. And last, we have the issue of the rings. And let me know if I'm close to my time, even though I'm not reserving any.
You have about 5 minutes.
Okay, thank you. The issue of the rings, throughout the case, the wife took the position that one day the husband came into the house and he took my rings. There was no, the rings are missing. I know we generally don't get into these kinds of put yourself in a position, but that was one of the things. This was a bench trial. One of the questions was, what woman would misplace $500,000 in rings? She secured what she thought were checks valuing $35,000 here, $29,000 there, but she didn't secure the 2 rings. One of the rings, she pretended that she didn't even know it existed. To suggest that you forgot about a 6-carat diamond ring, I think, as the trial counsel for Mr. Everett stated, seems implausible.
Well, let me ask, I think what counsel is arguing, that we're talking about a $450,000 ring. Well, that's one, there's 2 rings.
Right.
And I think the concern that they had is that the court ended up putting it in her column. And the argument is made, and I want you to respond to that, that there was a previous determination by a prior trial judge that did not find fault whether or not the husband, there was allegations that the husband took the rings, came to the conclusion, I am not attributing fault to either side. So as I understand their argument, they're concerned with the fact that at the final hearing, the court attributed that amount to the wife. And they're taking the position that that is a mistake. And how do you respond to that?
Okay, first and foremost, I want to be clear. When Judge Bauman did that, he did not find that the wife didn't have it, because that was not the issue before him. He found that the husband did not have it. That was the issue before him. It was not where the ring is. The husband asked for a hearing and said, hey, let me get this straight, let me get this clear. I do not have that ring, and I'm going to put on testimony to demonstrate I don't have that ring. That was what Judge Bauman found, that the husband didn't have the ring. Now, in the middle of the trial, of course, the wife didn't like that ruling from Judge Bauman, so she asked Judge Stoddard, let's revisit this. So, in lieu of saying, hey, we found, we're going to rely on Judge Bauman's finding, the wife invited the court to take testimony on that issue. And in fact, the wife did testify. And her testimony was, when I last saw the ring, it was with my other jewelry. It disappeared, and when it showed up, my husband had it. So in the middle of the trial, the wife's attorney asked Judge Stoddard to revisit the issue of the rings, and Judge Stoddard did just that, because he was not bound by the prior decision of Judge Bauman. I'm about to call Stoddard Bauman, and I apologize.
Mm-hmm.
So she basically lost round one, and she asked to have it revisited as a second time. And so Judge Stoddard, in fact, did so. Now, once the issue came up, it was not, even in the trial, and I recognize that that question was posed, it was not that the rings were missing. It was that he stole the rings. Now, at one point, in the middle of the hearing, and I want to cite the court because I think I noted the page number. At one point in the trial, the rings, the status of the rings is being discussed. And Mr. Everett's counsel, he doesn't say that the rings are missing. And he says they were last in the wife's custody. And I believe it's a quote, she got some things squirreled away. That's on page 2230 of the record. That doesn't sound like it's missing. He doesn't, at no point does he say the ring is missing. He's saying, I don't have the ring, but all the evidence points to her having the ring. And that is the position that his attorney takes, even when he uses the term, and I don't know where it came from, unlocatable. He's saying, my client can't locate the ring, and the last time the rings were seen, she had the rings. One of the arguments raised was that there was a scrivener's error, and I heard counsel today saying that the trial attorney did not take the position that, quote, it was a scrivener's error. But if you look at the reply brief on page 10, it says it's a scrivener's error. So when I describe this shell game of here it is, let me pull it back, here it is, let me pull it back, here it is, let me pull it back, that was what was happening below. Every time something seemed to be resolved, they won on ground one, they bring out ground two and re-argue ground two.
You have to wrap it up, please.
Your Honor, we ask that the court affirm the ruling of the trial court. There was no, the facts support the judge's ruling as it relates to the alimony issue, and in terms of the ring, in fact, one of the judges today asked the question about the motion for rehearing. If the judge had any concern about who had the ring and that it was mistakenly put in the wrong column, that issue was resolved when he denied the motion for rehearing. We ask that you affirm the trial court's ruling.
Thank you. Ms. Aronson, 4 minutes.
Okay, a couple of things. I would like to address first Judge Lucas's question to me that I gave an answer, but I have a better answer. You asked, did Ms. Coleman ever ask that the rings be considered non-marital assets? The legal answer to that is that she did ask for an equitable distribution in the initial petition. There is case law. I know one case off the top of my head, and I know there's a newer one. Once you ask for equitable distribution, you don't have to individually ask for it, the specifics within 61.075. So in fact, she did. I would like to comment on the notion that Judge Bauman found that the husband didn't have the rings, but didn't say anything about the wife. The quote is, "The whereabouts of the wife's diamond ring could not be determined. Each party stated it was not in their possession." So that was not accurate. Many of the, regarding the alimony, I think Judge Kazan pretty much got that. The nominal amount of alimony just basically reserves the right to consider in the future. And since he was an all-star baseball player, opportunities may come up.
Was there any record evidence that was put before the court as to, did you bring in like a private coach? You said, hey, this is what I work at, and you don't have to be, doesn't matter if if you maybe had some baggage in the past, as long as you can teach kids how to swing a bat, you can make some money at this.
There were no specific job offers brought in, and that's why there was not income imputed to him. But there was testimony about the types of things, scouting, teaching. There was one specific.
Who testified to that?
I know that the wife's counsel was doing the questioning. I believe, I'm not sure. But I know that, and there was one specific instance. They were talking about one particular man that he knew in the past, and they were trying to say that because he didn't have a college degree, that pretty much blocked all the doors. So there was quite a bit of talk of options being there, but nothing specific. That's why they didn't impute income to him. As for the wife causing possible roadblocks to him being reemployed, I was a little offended that the notion would be that if you are a victim of domestic violence, that you not report it or not take steps to protect yourself so that your ex can become reemployed. I believe that's beyond the scope of reasonable thinking on that. About the alimony, the thing was that the presumption of permanent alimony in a long-term marriage was just not addressed. It's not that the other factors weren't looked at, it's the presumption was not addressed. And regarding the carbon copies, the issue is fairly moot on that because the only reason she wanted to use them was to rebut some of these spurless accusations. And since the court found that there was no misconduct, it became unnecessary. But there was no request for the carbons. The pattern of giving the information to the accountant, the pattern was she would tell them what she needed and they would give it. And in the end, husband's counsel was given the opportunity to come and get them. She didn't want to release them to his possession because they were the only copies. They were carbon copies, so they were really difficult to copy. And husband was given the opportunity to copy them, but he did not take the opportunity. So there is no pattern of shell games or whatever on the part of the wife.
To wrap it up, Ms. Anderson, please.
Yes. We ask you to reverse the final judgment on these 2 points. Thank you.